Well, good morning, everyone. My name is Kathy Cubitt, and I'm the Advocacy Manager at CARI, the Center for Advocacy for the Rights and Interests of the Elderly. And I want to welcome you all today to our first in a series of webinars about the enrollment process for long-term services and supports in Community HealthChoices program in Pennsylvania. And we're going to start off with actually the most complicated part of the process, which is the financial eligibility component of the application. We will also, in future webinars, dive into the functional eligibility determination and some other aspects of enrollment. So as I want to mention, CARI is still operating during the COVID pandemic. If you have need any assistance with advocacy for an older adult or Community HealthChoices, please feel free to contact us at 1-800-356-3606, or you can go to cari.org, and there's a Get Help button on there if you prefer submitting an online request. David Johnson is our Community HealthChoices advocate and part of our CARI Line program. He's providing technical support today. And if you have a specific Community HealthChoices issue or concern, you can email him directly at johnson@cari.org. I want to go through some basic housekeeping matters before I introduce our guest speaker, Marcia Mikos. And I want to start off by saying that I know everyone's always eager to get slides. The slides will be sent to all registrants. This webinar is being recorded, and the recording and the slides will be posted on CARI's website for you to reference in the future. I also want to mention that we are going to be relying on the chat function today. Hopefully most of you have Zoomed before, and if not, you just want to go to the bar at the bottom and open up your chat box. And if you could put your questions, feedback during our webinar today, that'll be helpful to keeping this moving along, because we have a lot of information to cover. How the program is going to work today is Marcia will give her full presentation, and after she's done, we're going to open it up for questions and answers from you, the audience. So how that is going to work, if you could type your questions into the chat box, I will call 2 names at a time. The first name will be ask you to unmute yourself to ask your question, and the second name, you'll be in the batter's box or on deck to know that you'll be the next one to be called upon for your question. If there's any audio difficulty, I will read it, or if you prefer my reading it, you can just indicate that in the chat box. So without further ado, I want to move on to introduce Marcia Mikos, who has been at the Department of Human Services for many years in the Bureau of Policy, and she is a subject matter expert on this very complex topic of financial eligibility. I just want to preface her remarks by saying that Medicaid program is a combination of a federal and state partnership. So many of the requirements and that she'll be discussing today are required through the federal government. And although each state does have, you know, some flexibility, so there are differences among states in terms of how the Medicaid program operates. And for those of you that are new to this subject, Pennsylvania refers to its Medicaid program as medical assistance. So those terms are used interchangeably. So without further ado, Marcia, I'm going to turn it over to you, and thank you so much for doing this for us today.
Sure, Kathy, thanks for having me. Can everyone hear me okay?
Yes, we can hear you, Marcia. Thank you.
All right, thank you. So as Kathy said, my name is Marcia Mikos. I've worked at the Department of Human Services in long-term care for over 15 years now, but I'm still learning something new about it every day. So I'll give you the best I can here. What we want to talk about today would be long-term care eligibility requirements, the basics of the application process, fair consideration and the undue hardship waiver application process, spousal impoverishment, and some common reasons why an individual is determined not eligible the first time they apply and how they can become eligible. So first I want to talk about eligibility criteria. There are three main components for eligibility criteria, and those would be functional eligibility, non-financial eligibility, and financial. So first is functional eligibility. The CEO does not verify the functional eligibility. They don't do an assessment. They just need the verification. And that verification needs to show that the individual is nursing facility clinically eligible, meaning they have the nursing facility level of care, and it's verified by either the MA51 medical evaluation form for long-term care facility services or via the PA 1768 home and community-based services eligibility and eligibility change form for waivers. Non-financial eligibility for long-term care services is the same as it is for what we say straight medical assistance. We have to look at citizenship, identity, enumeration, and residency. Now for the financial criteria, we can break that down into two, the income and the resources. So for income, we are looking at the income of the individual applying, and we're taking their gross income and comparing it to 300% of the federal benefit rate. And that is currently in 2020, $2,349 a month. So it's very important to note that it's gross income we have to use. And if the client is married, we are only looking at the income of the spouse applying for long-term care facility services or home and community-based services. If gross monthly income is over $2,349 a month, and they're applying for long-term care facility services, that's usually still okay. For long-term care facility services, we have a second way to look at income eligibility. It's called the medically needy only, or M&O option. And what we do is we take 6 months of gross income and compare it to the 6-month M&O income limit. That limit is only $2,550. So it comes out to only $425 a month. However, for this M&O option, we can take 6 months of medical expenses. Medical expenses includes that client's nursing home's private pay rate. And we can deduct 6 months of the nursing home private pay rate from 6 months of gross income, then compare what's left to that $2,550 income limit. Since Pennsylvania's average private pay rate is almost $11,000 a month, it's very rare that someone will not be income eligible for long-term care facility services. The problem is people applying for home and community-based services with income exceeding $2,349 a month. They don't have this option to look at 6 months of income and deduct medical expenses like nursing home care. So we're going to get into that at the end of the presentation about spend down and how the people with excess income applying for waiver benefits can be determined eligible. Before we leave the slide, I want to talk about resources. The resource limit for someone who has income at or below $2,349 a month is $2,000 with a standard $6,000 disregard. So essentially, the individual can have $8,000 in countable resources and be eligible. If the individual applying is looking at long-term care facility services and has excess income, meaning income over $2,349 a month, then the resource limit is only $2,400. And that we do not have a standard disregard for that. It's a straight $2,400. Okay, next slide, please. So now I would like to talk about the application process really quick. The long-term care application process begins when the client or anyone acting on the client's behalf completes a long-term care application for benefits, or the PA 600L. And they're going to send that into the CAO, or the County Assistance Office, who processes the case. They should send any supporting documentation they have with the application. And once that application is received, the County Assistance Office is going to take a long look at it and review it. But hopefully what we really like to see is a verification of functional eligibility sent in with the PA 600L. It doesn't have to be, but it always helps us. So in addition to the PA 600L, we would need verification of functional eligibility. And again, that would be the MA51 medical evaluation form, as well as the MA103 admission and discharge transmittal form that the long-term care fills out, the facility fills out, or the PA 1768 if they're applying for waiver services. So the MA51 is important, and I'm sorry, I have to stop for a minute. My cat just jumped on the computer. Sorry. Okay, I'm sorry. The MA51 is important because not only does it tell us the level of care that it verifies that they're clinically eligible, but it's also important because the doctor has a spot on the form that they fill out that says whether the client is expected to return home within 180 days. So, and I'm going to get to that in a minute about why that's important. Aging Well completes questions 21 and 22 of the MA51, and they're the ones that have the final say on if they're clinically eligible or not. So it's very important we have the completed MA51. The MA103 is, again, it's just something that the nursing home fills out. It provides us the verified admission date to the nursing home. For the PA 1768, not only does it verify that they're clinically eligible, but it verifies the assessment date and which waiver they're applying for. Now, one thing before I leave this slide, current medical assistance recipients do not need to complete a new application for benefits. So if they're currently receiving Medicaid and now they're applying for long-term care facility or waiver services, they do not need to complete a new application. But what the CEO will do is send a few questions from the application highlighted to the client to have them fill out. These are questions about resources. That's the question about, did you give away any assets within the past 5 years? Questions that were never asked on a straight Medicaid application because they're not needed for straight Medicaid. Okay, next slide, please. So once the CAO receives the information, they're going to take a look at it and all the supporting documentation, and they're going to send the pending verification list to the client and the client's representative. The CEO needs to basically take a snapshot of financial eligibility as of the requested effective date, or the date that they need services to begin. So they're going to ask for bank statements as of a requested effective date. They're going to look at requesting, if there's a pension, they'll need an award letter to show the gross pension amount. They're going to look at titles to vehicles, deeds to properties, life insurance, cash surrender, and face values. We also need to verify any accounts, financial accounts closed or assets transferred within the past 5 years. So if any bank accounts were closed, we would want verification of the date the account was closed, the balance at the time it was closed, and where that money was deposited or how it was spent. So basically, we need a paper trail of bank accounts over the past 5 years. So the CO sends this pending verification list, gets the information back, and then has 30 to 45 days to process the application. They are going to send a notice of eligibility or ineligibility, and that notice must state the date eligibility begins, if they're eligible for long-term care facility services, the cost of care, meaning the amount the individual has to pay for their nursing home services that they pay to the nursing home. If they're not eligible, the reason for ineligibility, and also their fair hearing paperwork. Okay, next slide, please. So for home and community-based services, we're just looking at whether the client is eligible for benefits, meaning we're just looking at, is the income within limits? Are the resources within limits? Are they functionally eligible? But for long-term care facility services, we actually have a second step in that eligibility process. And that second step is determining the cost of care. So for home and community-based services, we're only looking at eligibility, but for long-term care facility services, they owe a cost of care every month. Common deductions from gross income are reviewed to see if they're applicable for the client. And then if they are, they're taken from the gross income to determine the cost of care. Some common deductions include the personal needs allowance, which is usually court-ordered guardian fees up to $100 a month, and this has to be verified via court order. A home maintenance deduction, and the home maintenance deduction is a great deduction. It is $805.10 a month, and the amount of that deduction increases every year in January. But it can be given for up to 6 months to individuals who are considered short-term, meaning they're expected to leave the nursing home within 180 days of admission. So this is the important part on the MA51 medical evaluation form that the doctor completes. If they're considered short-term, they need to provide us with just one bill or some type of verification that they have an apartment or a house in the community. That deduction helps them to pay for that shelter in the community so that they have that place to return to when they leave the nursing home. If the client is married and or has a child in the community, we look at a spousal dependent maintenance allowance, and we also can deduct verified medical insurance premiums, such as Medicare B monthly premium or supplemental insurance premiums. So we take all that off of the gross income to determine the cost of care. Okay, next slide, please. So the next major topic I'd like to discuss is fair consideration. So when the CEO is reviewing for long-term care eligibility, they must verify whether or not assets or income are transferred for less than fair market value during the look-back period. So this is what fair consideration is. If the individual or the individual spouse transfer assets for less than fair market value, then we are going to have to establish an ineligibility period for payment of long-term care services. So that means they're not eligible during this period for room and board in the nursing home or for home and community-based services. They would still be eligible for Medicaid, straight Medicaid, meaning physical health services would be paid for and prescriptions would be paid for. So the look-back period, or that 5-year period where we have to look at whether assets were transferred, is determined slightly differently depending on if they're a current MA recipient or not. So for individuals who are not current Medicaid recipients, applying for either long-term care facility or waiver services, the look-back period begins 5 years prior to the application date. But for current medical assistance recipients, if they're applying for long-term care facility services, the look-back period begins 5 years prior to the admission date. For current MA recipients applying for waiver services, the look-back period begins 5 years prior to the assessment date. And again, that assessment date is found on the PA 1768. Now, the length of the penalty period or ineligibility period for payment of long-term care services is determined by adding all the assets transferred in a calendar month, transferred for less than fair market value in a calendar month. For any months in that 5-year period where asset transfers totaled more than $500, we're going to add them together, add everything together for that 5-year period, every asset transfer, and divide by Pennsylvania's average daily private pay rate, which is currently $352.86. Next slide, please. If there is a penalty period or ineligibility period for long-term care services, it starts for a new applicant applying for long-term care or waiver as of the requested effective date or the date they're otherwise would be eligible. For a current long-term care or waiver recipient, the ineligibility period begins the first day of the calendar month after advance notice expires, and we give 15-day advance notice. So I just want to give you an example of that. Let's say Mr. J is open and receiving waiver benefits. On July 10th, the CO determines that he transferred $5,000 to his son without receiving fair market value. On July 13th, the CO processes the asset transfer in our system and sends a notice of the penalty period to all involved parties. The penalty period runs from August 1st through August 14th. And it starts August 1st because advance notice expired in July. So because we processed it on the 13th, 15 days later is approximately July 28th. So we say that advance notice expires in July. Had the CO processed it on, say, July 20th, 15-day advance notice would have expired in August. So the penalty period would have started in September. And this is just to make sure that everybody has enough advance notice to stop providing services and to find another way to receive services or pay for services. Okay, next slide, please. So next I'd like to talk about appeals versus undue hardship waivers. We get the question a lot about which is best and what's the difference. And this is in relation to penalty periods or fair consideration issues. So when an individual is determined not eligible due to an asset transfer, they have the right to appeal a decision, they can apply for an undue hardship waiver, or they can do both. An appeal is usually used when they don't agree with, they feel that fair consideration was received, or they don't agree with the monetary amount used to determine the penalty period. An undue hardship waiver is usually used when they agree, yes, assets were transferred, but we can't get this money back, and if the individual doesn't receive the services they need, they could be deprived of medical care that endangers their health or life, or they could be deprived of food, shelter, and other basic necessities of life. Okay, next slide, please. So to appeal a decision, it's like any other decision that is appealed. You have 30 calendar days to get the fair hearing paperwork that's sent out with the notice to this county assistance office. The county assistance office has 3 days to get that paperwork forwarded to the Bureau of Hearings and Appeals. The CO should, in the meantime, also be scheduling a pre-hearing conference to try to resolve the issue with the client or the client's representative prior to the hearing. In the meantime, while this is going on, BHA, or the Bureau of Hearings and Appeals, is going to schedule that appeal hearing so that both sides can give their testimony. And then the Bureau of Hearings and Appeals has up to 90 days from the appeal date, the date the appeal was filed, to provide a decision to all parties. Now for the undue hardship application process, the undue hardship application is just one page, front and back. Sorry, next slide, please. Thank you. So the application for undue hardship waiver is sent out automatically with any notice that involves a penalty period or ineligibility period. The undue hardship application is just one page, front and back, so it's nothing like the original application to request benefits. It needs to be, if you want to complete an undue hardship application, you need to get it to the CO within 30 calendar days of when the notice was issued. And you should be providing supporting documentation of why an undue hardship waiver should be granted. This is very individualized, but some examples of why an undue hardship waiver should be granted might be that the client was in good medical condition at the time the assets were transferred, so they didn't expect to go into a nursing home or need waiver services. So maybe a doctor's signed statement of medical health at the time the assets were transferred, or some reason why the assets were transferred, or why the transferred assets cannot be returned. So the CO is going to get this information, review it, make their thoughts known, basically make this potential decision, and send all the paperwork to the Bureau of Policy. Once it's received by the Bureau of Policy, we have 30 days to review everything provided, review the case, review what the CO's thoughts were on it, and send the CO a departmental decision. The CO will then send that departmental decision on an appealable notice to the client and all involved parties. So if the client transferred assets and a penalty period was established, they have a right to appeal. They have a right to apply for an undue hardship, and then they also have a right to appeal that undue hardship waiver decision. The next topic I'd like to discuss is spousal impoverishment. So spousal impoverishment or provisions were put into effect in 1989, and they allow a married individual who applies for long-term care services to protect a minimum level of income and resources for the spouse in the community, so that the community spouse does not become impoverished. And when I refer to a community spouse, it's the spouse of the individual applying for or receiving either long-term care facility services or waiver services in the community. So when a married individual applies for long-term care services, we must determine the couple's countable resources as of either the date the individual entered the long-term care facility for at least 30 consecutive days, or the date the spouse is assessed as functionally eligible for waiver services. So we're going to use the resource assessment form, and again, it's just one page that needs to be completed front and back, and it should list all of the couple's countable assets. That would be whether they're jointly owned or solely owned by either spouse. The CO is going to take that. They also have to provide verification of all these resources as of that resource assessment date that we need. So we need a snapshot of resources as of the resource assessment date. We're going to go through it, we're going to review it, and we're going to add everything, all the countable assets up, and divide that amount in half. Usually, that half the total resources is called the protected share. And next slide, please. So the protected share of resources, I said, is usually half the total countable resources. It's usually half because the federal government set forth a minimum protected share and a maximum protected share. The minimum currently is $25,728, and the maximum is $128,640. So the protected share has to fall within those limits. So let me give you an example of that. Mr. B entered the long-term care facility on April 15th, and he was going to be there for at least 30 consecutive days. He and his wife owned $84,000 in countable resources as of April 15th. So the protected share that Mrs. B gets to keep free and clear, that we're not going to touch for Mr. B's Medicaid services, is $42,000, because that's half the countable resources. Now, if they had only owned $40,000, then half that would be $20,000, but we cannot make the protected share less than $25,728. So Mrs. B would be allowed to protect $25,728. Next, The next component of spousal impoverishment is the spousal maintenance allowance. So income of the institutionalized spouse may be transferred to the community spouse if the institutionalized spouse has that money to give, and if the community spouse needs that money. So this is for long-term care facility services only, because we're going to take money of the institutionalized spouse and deduct it from the gross income when we're determining the cost of care. And we can transfer that if the institutionalized spouse agrees to transfer it to the community spouse to help her pay for her shelter and utility costs in the community. So this is very beneficial to a community spouse. So any married couple where one individual is in a long-term care facility, we are going to be requesting shelter and utility verification as well as income of the community spouse. So it's very important that they provide all this information so we can determine the spousal allowance. Okay, next slide, please. Thank you. So I think the hottest topic here would probably be the common reasons for long-term care rejections and how we can get around that and make them eligible when they reapply. So I said before, I was working for over 15 years in long-term care policy. And I think the most common reasons for long-term care rejections are failure to provide documentation, excess income, and excess resources. So we know for failure to provide documentation, the CEO understands, we all understand that this is a very complex application. It's so much that they have to verify in a very short time. And it's often people's children who were never aware of their parents' assets, and now they're dealing with their parents going into a facility or needing help in the community, plus dealing with this application. But unfortunately, we have to follow the rules in our timelines. So if a client does not provide all the information needed and the CEO, County Assistance Office, has to reject, there are some things they can do. I always suggested to clients that they appeal, because that's going to make sure that the original requested effective date that care is needed on that application is saved. And it buys more time to provide verification that we requested. In addition to that, or instead of that, the client can ask for reconsideration. And that means they would have to provide all requested income and resource verification, every piece of it, within 60 days of the application denial date. If they do that, we're going to again honor the original requested effective date and application date, and they do not need to fill a new application. If they had appealed or did both, also with the appeal, if they provide all verification, in addition to saving the date, they don't need to fill out a new application. Next, I'd like to discuss excess income. So as I said in the beginning of this presentation, for long-term care facility services, it's going to be very rare that someone is ineligible due to income. I've only ever seen it happen, I think, twice. But for home and community-based services, that's where we have the problem, because they cannot have income exceeding 300% of the federal benefit rate, currently $2,349 a month. In just a minute, I'm going to get back to different options for this. Let me just talk about excess resources quickly. If the client who has income at or below 300% of the federal benefit rate has resources, countable resources, they cannot exceed $8,000, which is $2,000 with our standard $6,000 disregard. If their income is over 300% of the federal benefit rate, then their resources cannot exceed $2,400. And this often happens where that a client applies before their resources are reduced. So on the next slide, we're going to talk about how to reduce resources. So there's different ways to reduce resources. If the client reduces the excess resources by purchasing an irrevocable burial reserve and or spending the excess resources on medical expenses, then we can act as if the resources never existed and go back to that original requested effective date where they need care to begin. If the individual chooses to spend excess resources on non-medical expenses, like paying off a mortgage or buying a car, that's fine, but the individual is not resource eligible until the day after the resources were reduced. And this is very important. I'm going to give an example of this. So Mr. C is requesting payment of long-term care facility services effective May 10th. He applies for benefits on June 15th with excess resources. On July 11th, he pays off his mortgage. So he is eligible for payment of long-term care facility services effective July 12th, the day after he reduced the resources on a non-medical expense. So now, because our resource limits are so low, he's not going to have enough resources left to pay the long-term care facility what he owes to them for the care he received from May 10th through July 11th. Now, whether they reduce resources on medical expenses, it's very important that they keep a paper trail of how they reduce the resources. So any bills they paid, copies of the bills, and how the money, like where the money was withdrawn, which account was it withdrawn from, when was the bill paid. If we do not receive fair consideration, if they did not receive fair consideration or cannot verify it, then we're going to establish an ineligibility period. And before I leave the slide, I just want to touch on irrevocable barrier reserves. Every county in Pennsylvania has a limit on barrier reserve costs. And what we do every year, we ask different funeral homes to tell us what their average costs are. And then we take, every county takes that and averages it in. So the CA or the client cannot get a burial in excess of the amount in that county. If they do, then it could be a penalty period would be incurred. So that's just something to watch. And every county knows their limits. It's in the handbook. So anyone can check with the county assistance office to see what the limits are. Funeral homes are also very aware of this process and usually know the limits as well for their county. Okay, next slide, please. So for individuals who are applying for waiver services with income exceeding 300% of the federal benefit rate, they have the option to spend down income. If they choose to spend down income, they are going to be doing it to a straight medical assistance category limit. So we're not looking at any of the higher income and resource limits for long-term care. So currently, the spend down Medicaid income limit is $805.10 per month, or they can do a semi-annual spend down to $2,550. And again, that's semi-annual. So, and just as a reminder, the problem with waiver services is that we don't have that M&O option for long-term care. Like we don't have the ability to use the nursing home private pay rate and deduct that from income. If the client can afford, it's rare, we don't have a lot of these cases because it's hard for a client to live in the community off of $805.10 a month, or $2,500 semi-annually, which comes to $425 a month. So usually this is a better option if a client lives maybe with their children or something like that. But if they decide to do that, that's fine. But they're going to have to pay medical expenses, incur and pay medical expenses in the beginning of a month, provide us with that verification. The day after the expenses were incurred or the bills were paid, medical expenses or medical bills, through the last day of the calendar month is when they would be eligible for waiver services and Medicaid. Then they would have to do that every single month. That's when they spend down to $805.10 a month. If they want to do a 6-month limit, that's fine, but they would have much higher medical expenses they would need to incur and spend down, and then they would be eligible for 6 months at a time. So I'm going to get into the differences between the two. It's non-money payment, or NMP, is when you spend down to $805.10 a month, and medically needy only, or MNO, is the $2,550 semi-annually. There are some different benefits to each of those, and what we want to do is find the way that's most beneficial to the client. And before I leave the slide, I just want to stress, this is not a way to get around fair consideration. Fair consideration and spousal impoverishment do not apply to straight Medicaid categories, like these spend down categories. If assets are transferred and an ineligibility period is going to be assessed, no one can say they want the option of spend down. This option is only allowed if they are not eligible because they have excess income, over 300% of the federal benefit rate, and they're applying for waiver services. Okay, so the next 4 slides are examples of different ways to spend down, NMP versus MNO, whether they're single or married, and you're going to get copies of these slides. So I don't want to just read the slide word for word in the calculation. So you'll have these, and you'll have my contact information if you have any questions. So I'd like to jump to slide 20. Because this is a comparison of the 2 different options, so you can see the benefits of each. So for NMP, that's the monthly. You're going to see that the income, it shows 2 different income limits. NMP, if you're married, we need to count the income and resources of the community spouse and compare it to that 2-person income limit, which is $1,208.30 a month. And again, for a single person, it's $805.10 a month. But for MNO, we do not count, if you're married, we do not count the income and resources of the community spouse. We only compare the income and resources of the client applying to $2,550. Same thing for resources. The resource limits are there. For NMP, you have to count the resources of the community spouse and compare to the $3,000 resource limit for 2 people. Again, for MNO, the resource limit is $2,400, and if there's a community spouse, their resources are not counted towards that limit. When it says deeming, that just means, yes, the community spouse's income and resources are counted for NMP, but they are not for MNO. Duration, I touched on this earlier. For NMP, it would be from the day after the services, the medical bills were incurred or paid through the last day of the calendar month. But for MNO, we would look at a larger amount because we would do 6 months at a time. So they'd have to spend down 6 months worth of income, and then we give 6 months of eligibility. The benefits of NMP are a higher income limit. The benefits of MNO are a higher resource limit. There's no deeming, and there's a semi-annual eligibility period, meaning you have 6 months of eligibility. We see many more, we don't get a lot of these cases, but many more people choose the NMP option. Now there's one on the next slide. We're going to talk about medical assistance for workers with disabilities. This is another option for individuals in need of home and community-based services who have excess income. Instead of spending down, they could be authorized in this medical assistance category with a waiver. So they would get the Medicaid and waiver benefits. But the problem is they have to meet the MAWD eligibility requirements. So they have to be within the age limits of 16 through and including age 64. They must be employed and getting paid, disabled according to the Social Security Administration or our medical review team. They have to have income below 250% of the federal poverty income guidelines. And that is currently, and this changes every year, but it's currently $2,659 for one person, or $3,592 for 2 people. Resources at or below $10,000, so it's a higher resource limit, and they have to be willing to pay a monthly premium, and that premium is 5% of the net monthly income. So before we leave the slide, I just want to stress that when we say employed and getting paid, we are not, it doesn't have to be a certain amount of hours worked a week or anything, or a certain type of job. If they can get a verification, like a neighbor's signed statement that they're walking their neighbor's dog once a day or once a week and they're getting X amount of money, then they are employed and getting paid for us. So this could be very helpful. Oh, also I want to mention that you see the income limit there. Unlike for long-term care and waiver categories that we use gross income right off the bat, if you have someone with wages, they can have unearned income, but if they at least have a few dollars in wages, this is a great way to become eligible, because although the income limit for one person is $2,659 a month, they could be making much more than that and still be income eligible, because we have a lot of deductions that we don't have for other categories. We take for earned income, we take $65 off of that gross earned income, and then we divide the remainder in half. And that's the amount of wages we would count. Then we take $20 off of the unearned income, and we also can look at different work-related impairment expenses, like if they need certain equipment at work to work or certain transportation to get to work because of their disability, we can deduct that. So even if they meet the other standards and they have excess income higher than the income limit for MAWD, they should still apply. Well, I want to touch on the monthly premium. Again, I want to stress it's net income that's used to determine the premium. If the client's married, we're only looking at the income of the client applying to determine the premium. And again, it's usually beneficial to pay the 5% of net monthly income as a premium in order to get the waiver services if that's what they need to do. But that's up to the client. So, and the last slide is just my contact information. If you have any questions about this that we don't cover today, you can certainly contact me, email or call me. The DHS website link is there. The long-term care handbook link, and also our Compass website. An individual can apply via paper, the paper 600L, or they can apply online at Compass. Does anybody have any questions?
Well, this is Kathy, and Marcia, thank you so much for that very informative presentation. We're so glad that this was recorded and we have your slides, because I'm sure we're going to want to go back and reference a lot of this material. So thank you. We do have a number of questions in the chat. I want to encourage people to continue to put questions in, and any feedback is also welcome. I'm going to start with a question that was actually asked early on but then retracted, but I think it may be helpful for everyone to hear. So I'm going to read that, and then I'm going to call on Dina Kurtz. You'll be first up after this first question is asked, and then Joanna Jarzabowska, you'll be following Dina, so you're in the batter's box. So the first question, again, that was retracted, is what is enumeration?
That's just a verification of Social Security number.
Okay, thank you for that. So Dina, can you unmute yourself and ask your question as concisely as possible?
What is the residency requirement for eligibility?
If they are, we really don't have, like, they don't have a minimum time frame they have to be in Pennsylvania. We don't have that. If they are planning to remain in Pennsylvania and they're in Pennsylvania, then they meet the residency requirement.
Thank you.
Okay, so Joanna, you're next, and then Jesse Foster, you'll be following Joanna.
Can you hear me?
Yes.
Okay, great. Does the spouse's income need to be included in the application if they are separated but not legally divorced? We did have some calls from individuals who needed to apply, and even though they were still legally married, they haven't been in contact with their spouse for many, many years, and some had questions whether they still needed to include that information under the spouse's income.
They do need to include that. Strange spouses are still counted. We have to look at spousal impoverishment. So we would need to get, if they haven't been in contact, the CO would need some type of verification of that if they can't get the information.
Okay, thank you.
Okay, so next up is Jesse, and I'm seeing an unmute option. If you go into the box with your name, Jesse, actually it looks like you are unmuted. Did you want to go ahead?
Yeah, thank you. I was just wondering about the timing and how that works in conjunction with folks applying through the IEB. You mentioned 30 to 45 days with the county assistance office, but I know it can take a little bit longer with the IEB, so I was wondering how those work together. Thank you.
Sure. I do not know a whole lot about how the IEB works. That's more of the Office of Long-Term Living's territory. But I will say the 30 to 45 days is from when we receive the application. So if a client calls the IEB, that starts on their side, the process, but that doesn't start it on our side. If you apply, if you haven't met with the IEB first and you apply on Compass on our electronic website, online, it should route to both the application will route to us when it's completed, the county assistance office, and it'll route to the IEB so that the IEB knows that someone's interested.
Okay, I also, Shelley Spear, you're going to be next, followed by Felicia Alexander. And I just wanted to add, Jesse, that Carrie will be having a part of this webinar series in terms of that whole role of the IEB and that part of just getting through the process. I also see in the chat, can Carrie help with these applications? The details are daunting. Yes, they are. I mean, this is challenging for professionals that have gone through this application process multiple times, helping clients. So yes, Carrie is available to help. If you're connected with a social worker, a community social worker, or some folks have attorneys they're working with, but it's always good to get some support to get through this, because more often than not, people are in dire need of these services. So it helps you get through the process much faster. So with that, Shelley, can you unmute yourself?
Yeah, can you hear me?
Yes, thank you.
So if somebody is already in a long-term care facility, they, have not been eligible for Medicaid, and then their resources get to that limit, the application process starts. Like, how long a process is it? Because at some point, they're not going to have the money to be able to pay the long-term care facility. So just in terms of how long does the process takes and what happens in the meantime, I guess they have to wait till they hit that asset limit, right?
Nursing home billing offices are very aware and very good with this. So they usually, from what I've seen, is they'll usually tell the client or the client's family, hey, let's get an application done when they're close to the limit. Also, we can go back and look at retro assistance. So let's say you wait till the client has $8,000 in resources, so they're right at that resource limit. If need be, we can go back from up to the first day of the third calendar month prior to the application date and look at retroactive assistance. So we don't like people to hold, certainly don't wait till the last minute. We don't suggest that, but if need be, we can go back that far. So if you apply in July 10th, let's say, then we could go back to as far as March 1st if need be.
Thank you.
Okay, so next up is Felicia Alexander, followed by Michelle Ramp. Felicia, can you unmute yourself, please?
Hello?
Yes, we can hear you.
Yeah, I really didn't have a question. I just had a more of a comment, just to say thank to Marcia, just to say thank you for an excellent presentation, and thank you for providing the slides, because I know the slides is something I will probably be going through as I, talk to different folks, to try to help them through the process. So I really just want to say thank you for an excellent presentation, and thank you for providing the slides. That's all I had to say. It wasn't a question, just a comment.
Okay, I'm sorry.
Welcome. Thank you.
Thank you, Alicia. Okay, so next up, I'm losing track here. We're going to have question. Michelle Ramp, followed by Sally Eberhardt. Michelle, can you unmute yourself?
Hello, can you hear me?
Yes, thank you.
Thank you. I was wondering how the department calculates veterans benefits income. When they calculate the income for eligibility purposes for home and community-based services, is only the aid and attendance portion of that payment considered income?
That's the portion that's excluded. Everything else is counted.
Okay, so when I count the gross income, I back out the aid and attendance portion.
Yes, but we would
Okay.
still want verification of it, of the calculation, but yes.
Okay, so just to extrapolate for a minute, let's say my excluding the aid and attendance, my client's income is $28,0510. She has to spend $2,000 a month on medical expenses, and then she would be eligible?
Unfortunately, yes.
Okay. All right. I just wanted to understand the calculations. Thank you.
Yeah.
Okay, thank you, Michelle. Daniel Lewis will be following Sally Eberhardt. Sally, do you have your question?
Hi, can you hear me?
Yes, thank you.
I just was wondering, because this happens a lot with people I work with, if somebody is gathering their financial documents together and they miss their deadline, can their case be automatically reopened? And is there some kind of time limit between when an application starts and how long, because in some cases it takes a while for them to get all their financial documents together.
Right. We usually can only hold the application for up to 45 days. Now, there are extenuating circumstances. Sometimes we know that some of these places are hard to get a hold of. Also, if we do need to reject the application, again, you can appeal or you can ask for reconsideration, or you can do both. And that's going to hold that original date. You're not going to need to reapply if you get the information to us, and it just gives you more time.
Okay, thank you.
All right, thank you, Sally. Next up is Daniel Lewis. If you could get ready with your question, and then Pam Berg. I wasn't quite sure if you had a question, so we'll check in with you after Daniel. Go ahead,
Just
Daniel.
call this number and you got a human being.
Thank you for calling the PHMC Health Network. For English,
Okay,
our
Dan,
options have been modified.
if everyone who's not speaking, can you mute yourselves, please? And
Health
go
insurers
ahead.
are offering telehealth visits to meet the medical and behavioral needs of our
I'm ready whenever that stops.
Yeah,
in-person visits are also
I think
available
you
based
might
on
have to talk over that unless David's able to identify and mute that individual.
our health centers are also offering.
Okay, there you go. Thank you,
Okay.
Daniel.
Thank you, Kathy. My question is, I'm not sure I understand. I've heard something called a pooled income trust. Can you explain what that is and how that might work to reduce somebody's income?
Okay, it's trying to think of how to answer this. Have you ever dealt with our Office of General Counsel?
Me? No.
Yes. Okay. Basically, it's a workaround. If income exceeds $23.49 a month, you may be able, the client may be able to transfer some of their Social Security income into a pooled trust. That trust would need to pay out that amount of income each month for medical expenses.
Just for medical expenses?
Yes. Yep.
Okay. All right. Thank you.
Mm-hmm.
Okay, thank you, Daniel. Pam Berg, did you, I wasn't quite sure if it was a comment or a question. Did you want to unmute yourself and ask if you didn't, we can clarify whether in fact you did have a question? Okay, maybe Pam's no longer here. Okay, so if I could just ask one other question, and if there's anyone else that wants, it looks like we've gotten through the questions in the chat box. Oh wait, I think I see one more coming in from Karen Chenoweth. So we will go to you in a moment, Karen. Marcia, are you able to quickly say what's involved with the annual redetermination process? I know that's been on hold in part because of the COVID-19 pandemic, but I didn't know if there was anything, I know oftentimes people get dropped during that annual redetermination process, so I didn't know if there was anything you could comment on in terms of what's involved in terms of your part of the application with that.
Sure. We are still sending out renewal packets. But if all the information is not provided, then we are not going to process the renewal and we are not going to close benefits. We cannot close any benefits during the emergency period.
Okay, and what's involved with what kind of information is asked during the redetermination? Can you quickly outline that for folks?
Yes, it's basically you're going to get a pre-populated PA 600L application in the mail. And you would need to cross out and change any, and it gives you instructions to cross out and change any, update anything that changed. And then you would need to provide updated things that changed, like you would need to provide bank statements. You wouldn't need to provide a bearer reserve again or something like that. Things that we already had or don't change, normally don't change, you wouldn't need to provide.
Okay, thank you. That's very helpful. But it is important that people pay attention to that because you don't want to have any lull or drop in services. So Karen, are you able to ask your question now?
Can you hear me?
Yes, thank you.
Oh, thanks. Yes, what would be the best practice to empower family members who do not have POA or guardianship, who need to help their aging parent gather financial documents whilst their parent is not able to assist in gathering such data due to their health needs?
If they don't have a power of attorney set up, we have a form. If the client can just sign it, even with an X if it need be, that gives us the right to help get the information. The county assistance offices have this form. They know, everyone knows about it. So we can try and help. Like we can contact, insurance companies are usually pretty bad. We try to reach out to them to get help with that. If the person is diligently trying to get us this information, we are going to do it and asks for help. We're going to do our best to help and not reject the application.
Is there a number or name to that form that we could let people know about to ask when they're in contact with the CAO?
Yeah, it's known as the PA4.
The number 4?
PA-4.
PA-4.
Yeah.
Okay, thank you very much.
Sure.
Okay, I don't see any other questions in the chat box, and we've gone a few minutes past 11. So again, if anyone wants to quickly type in a last-minute question, now's the time to do it. Otherwise, I want to thank you again, Marcia. This was a very, very informative, helpful presentation. You presented a lot of complicated information in a very understandable way, and we all thank you for that. So with that, and I see no further questions, we'll end today's webinar. And thanks again to everyone who participated. And we appreciate everyone's time, and stay well and healthy during these very challenging times for all of us. And thank you. This concludes our presentation.
Thank you, Kathy.
Oh, thanks, Marcia.